It begins with a bizarre question about a face tattoo signifying a life of crime, but it spirals into a case that will challenge everything you think you know about justice. We're in a sentencing hearing for Patrick Benson, a man who is already admitted to a horrifying charge, assault by choking a family member. The prosecution is silent, the plea deal is on the table, and prison seems like a certainty. But in a stunning, almost unbelievable twist, the person who will fight hardest to keep him out of jail is his victim. She's about to take the stand for the defense, ready to tell the court that she was responsible for the attack. Get ready for a tense, emotional, and unpredictable hearing where a judge must untangle a web of trauma, manipulation, and a last-ditch defense involving a shocking claim of sex addiction.
Yes, Judge.
All right, the court is calling 2020 CR 4996, State of Texas versus Patrick Jeremy Benson. Could I have parties announced for the record, please, for the state?
Ray Garcia for the state.
For the defense?
Terry Carter for defense.
All right, we're proceeding with the sentencing by video because of the pandemic. Any objections from the state or the defense?
No, Your Honor.
No, Your Honor.
The court will note for the record that the defendant entered his plea by video on April 5th, 2021. The court found that there was sufficient evidence to find the defendant guilty, and the court found the defendant guilty of the offense of assault, choking family. According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. The state will remain silent on his application for probation or deferred adjudication. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
All right, the state is silent. Defense?
Your Honor, if I may, you had requested that the complainant appear on the Zoom today. Can I ask to check if Ms. Mayfield is present? Chantel Mayfield.
Yes. Are you Ms. Mayfield? Yes, Ms. Mayfield is present.
We also have a character witness, Ms. Little. She should have just logged on.
Yes, I'm present.
Are you listed on the Zoom screen?
I don't see myself on the Zoom screen, Your Honor. I'm not sure what it's listed as, but Lillian Little is my name.
I believe she's wearing a blue floral blouse, Judge.
All right. Defense, you may proceed.
We would like to call Ms. Mayfield.
All right, Ms. Mayfield, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record, please.
Chantel Mayfield.
Judge, may I proceed?
Yes.
Ms. Mayfield, are you the complaining witness in the case against Mr. Benson?
Yes.
And have you had interviews with the state in this case during the pendency of his case?
Yes.
Okay, and have you expressed to the state that you wish for Mr. Benson to be given probation?
Yes, I have.
This is the moment the entire case flips on its head. The defense isn't calling a friend or a family member as their first witness. They're calling the complaining witness, Chantel Mayfield, the victim. In a domestic violence case, this is a massive and often controversial move. The prosecutor's entire case is built on protecting her, but she is now voluntarily taking the stand to help the man who assaulted her. The judge knows how powerful this testimony can be. The central question is no longer just what the defendant did, but why the victim is now actively advocating for him to receive probation. Pay close attention to her reasoning. It reveals a deeply complicated and heartbreaking dynamic that the judge will have to navigate. This is where the legal proceedings become a deep dive into human psychology.
Can you explain why you'd like for him to be given probation?
Yes, because the incident that happened that night, he did come in the house and went straight to sleep. I feel like I kind of instigated the altercation by waking him up out of his sleep. And, part of it is my responsibility for what happened that night. And I was just trying to, I don't think he deserved, jail time for something that I instigated. And that was just my opinion and why I said that.
And Do you and Mr. Benson have a child together?
Yes, I did not know I was pregnant at the time. I was hormonal because I did something I would normally do, which was, pick at Mr. Benson. And since then, I have had his daughter.
Okay, and how old is she?
She's now 9 months.
And has Mr. Benson had access to the child?
By way of family members only. He doesn't get to, I guess, interact with his daughter like a normal father because she doesn't really know him too much. She cries a lot. So, it's and I kind of feel responsible for that as well because, he would have a better relationship with his daughter if it wasn't for this case.
Okay, and is there currently a no contact order between you and Mr. Benson?
Yes, there is.
And is that why visitation has been difficult?
That is correct because she would be more calm if I was there.
Is that because you tend to be the primary parent?
That is correct.
And are you asking the court that if Mr. Benson is given probation, that the no contact order be removed?
Yes, that is correct.
And is that in order to promote the family unit?
This is an absolutely textbook and tragic example of a victim taking responsibility for their own abuse. Listen to Chantel Mayfield's language. I kind of instigated the altercation. Part of it is my responsibility. I was hormonal. She is systematically downplaying his violence while magnifying her own perceived faults. She even reveals they have a 9-month-old daughter, a child conceived around the time of the assault, and uses the need to promote the family unit as the reason to drop the no contact order. She's not just asking for leniency, she's asking the court to rebuild the very situation that led to her being choked. It's a powerful, gut-wrenching plea, but one that puts the judge in an incredibly difficult position: honor the victim's wishes or protect the victim from herself.
The relationship in your family unit?
That is correct. Patrick Benson is a good father, and I want him to have that father-daughter bond that, our daughter deserves. This just to build that relationship with his new daughter.
Do you feel that Mr. Benson is a danger to you or your daughter?
No.
Okay, I have no further questions for this witness, Your Honor.
Stay.
Judge, we're silent, but I just have a factual clarification questions. If I may proceed.
Yes.
So just to clarify, you feel responsible for the fact that he threw you on the ground?
No, I said I feel responsible for the start of the altercation, and that was pretty much it. Just the start. It wouldn't have been an altercation had we just spoke like adults the next morning. But the fact that I woke him out of his sleep to start the altercation is what I take responsibility for.
Okay, but after that, there was an assault, right?
Yes, it was.
And he did throw you on the ground?
He didn't throw me on the ground. He pulled.
The prosecutor is silent on sentencing, but not on the facts. And here, he does his job brilliantly. He cuts through all the emotional appeals and self-blame with cold, hard questions. He forces Chantel to move past her narrative of instigation and confirm the violent acts themselves. He did throw you on the ground. He also choked you. Notice how she immediately tries to soften the reality again. He wasn't intentionally trying to choke me, she claims, framing it as him just trying to stop her from leaving. But the prosecutor corners her with her own police statement, reminding her that she reported she could not breathe. He's not being cruel. He is ensuring the official record reflects the violent reality of the crime, not the minimized version the victim is now presenting.
I was walking away and he pulled my hair and I fell to the ground.
Okay, and he also choked you?
He wasn't intentionally trying to choke me. Let me make that clear. He was pretty much trying to stop me from leaving because I woke him up to talk to him. Then when he started talking, I started trying to get away. and he did not want me to leave without talking it through. And being that I was very hormonal at the time, I did not allow him to talk to me and talk it through. So that's why, that's how the choking incident happened. He was trying to talk to me and I wasn't, and I was trying to flee.
Okay. But you told the police that he choked you with one hand, right?
What, with his hand?
With
I did
one
not say he
hand.
choked me with his hand. I said that he was trying to he was trying to stop me from leaving, and he used, like, I don't know if it was his arm or his forearm, and and I, at one point I could not breathe.
Okay. Your Honor, I just refer back to the stipulated evidence and the PSI. No further questions.
All right, any further questions, defense?
No, Your Honor.
All right, defense, call your next witness.
We'd like to call Ms. Little.
All right, Ms. Little, if you can raise your right hand for me, please. You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, state your name for the record, please.
Lillian Little.
All right, defense.
Good morning, Ms. Little. Thank you for appearing today. Can you tell us how you know Mr. Benson?
Yes, I'm a client of Mr. Benson's.
And by client, what does that mean? What service does he provide you?
He provides auto detailing service for me, so I've hired him to detail my vehicle and clean my vehicle.
Okay. And how long have you known Mr. Benson?
I've known him for a little over a year.
And would you say that you're friends as well as having that work relationship?
Yes, I would.
Have you had an opportunity to, get to know Mr. Benson, who he is as a person?
Yes, I have.
And has Mr. Benson shared with you things that have happened to him in his life?
Yes, he has.
Okay. And Miss Little, what do you do for a living?
I'm a caseworker with Child Protective Services.
And how long have you been a licensed caseworker?
I've been a licensed social worker for about 7 years, and I've been with the department for about.
Just when this case couldn't get any more bizarre, the defense calls their next character witness a licensed caseworker for Child Protective Services. This is an incredibly audacious move. The defense is leveraging Lillian Little's professional title to lend credibility to her assessment of the defendant. A person whose entire job revolves around protecting children from harm is testifying on behalf of a man who admitted to choking the mother of his infant child. She speaks about his traumatizing childhood and self-medicating, effectively painting him as a victim in his own right. This is a high-risk, high-reward strategy. Will the judge see this as a compelling argument for rehabilitation or as a stunning display of poor professional judgment from the witness?
7 years.
Okay, so is it fair to say that you have a pretty good ability to decipher certain things regarding a person's need for...
And there it is. The defense just played a wild card: sex addiction. After building a case around the defendant's childhood trauma and the victim's forgiveness, the attorney introduces a new, highly controversial element. They are suggesting that his issues are so deep-seated that they manifest as a diagnosable addiction alongside his substance abuse problems. This is a deliberate strategy to frame his violence not as a character flaw or a simple criminal act, but as a symptom of a complex disorder that requires therapy, not prison. It's a modern therapeutic defense aimed squarely at convincing the judge he's a candidate for rehabilitation. The question is, in a case of violent assault, will this argument generate sympathy or just raise more red flags?
Rehabilitation?
Yes, ma'am, I would say I do.
Okay. And in your conversations with Patrick, have you ever discussed with him him seeking treatment?
Yes, we have.
The arguments are over. The witnesses have spoken. Now the judge is cutting straight to the source. She is putting the defendant, Patrick Benson, on the stand under oath. This is the ultimate test. The judge has read the report saying he doesn't accept responsibility, and she's heard his victim take the blame for him. Now she wants to hear it from his own mouth. His freedom is hanging by a thread, and it all comes down to this moment. Can he articulate genuine remorse? Can he convince her that he understands the gravity of what he did, or will he continue to minimize his actions and prove that he hasn't learned a thing? The entire outcome of this hearing rests on his next words.
I have discussed that with him.
And why do you believe Mr. Benson needs treatment?
Who is he?
He's an asshole, sir.
He's a monster.
I feel that at times Mr. Benson might be self-medicating, and I was just a little concerned about some of the things that were going on in his life where he would maybe self-medicate and just try to numb some of the feelings and the pain that he was going through at the time.
Would you agree, based on the conversations you've had with Mr. Benson, that he had a traumatizing childhood?
Yes, ma'am.
And is it your opinion that he self-medicates in order to deal with some of the trauma that he's experienced?
Yes, I believe so.
And has he ever indicated to you that he has had treatment in the past?
He has not. He indicated to me that he has not had treatment.
Okay. Are you aware of the facts that are alleged in this particular case?
I am.
And are you aware that Mr. Benson has pled no contest to those allegations?
Yes, ma'am.
And do you believe that Patrick Benson is a danger to society?
No, I do not.
I have no further questions of Ms. Little.
This is a masterclass in judicial accountability. The defendant tried to use the soft, dismissive phrase, "I put my hands on her," and the judge immediately and brilliantly shut it down. By sarcastically comparing his violent act to a handshake or a fist bump, she exposes the absurdity of his minimization. She is refusing to let him hide behind euphemisms. She forces him to confront the legal reality of his charge: assault, choking, strangulation. Furthermore, she directly addresses the victim's testimony, stating that Chantel needs counseling for taking responsibility for his violence. The judge is drawing a clear, unambiguous line. His actions are his alone, and she will not tolerate any attempt to shift or downplay the blame.
All right, any questions?
None from the state.
We would ask that the witness be released, Judge.
All right, the court will hear argument. Defense?
Judge, if I may, I had previously submitted to the court a certificate of completion for the batter's intervention prevention program that Mr. Benson has completed. I would like the court to take notice of that certificate of completion. Additionally, after reviewing the TAP evaluation in the PSI, it is apparent that Mr. Benson has never received any treatment for his substance abuse. There is also an indication in the PSI as well as the TAP that he would benefit from counseling regarding sex addiction.
Wait, what?
Mr. Benson was not
This is a jaw-dropping, self-inflicted wound. In the middle of his own sentencing, while begging the court for a chance at probation, Patrick Benson admits that if he were drug tested right now, he would be positive for alcohol and marijuana. This is a catastrophic failure of judgment. He is essentially confessing to the judge that he is actively engaging in illegal activity and demonstrating a complete lack of the self-control required for probation at the very moment she is deciding his fate. You can feel the air go out of the defense's case. He has just handed the judge every reason she needs to deny his application and send him straight to prison. It's a stunningly candid and incredibly foolish admission.
previously receptive to treatment, which was indicated in these reports. After reviewing these reports, he has made the conscious decision that he does have a problem and that these issues are going to continue if he does not get treatment. He has already completed orientation with Miss Barbara Curtis for intensive outpatient treatment, which is also recommended in the TAP evaluation. So we are asking the court at this time to grant our application for probation and allow Mr. Benson the opportunity to address these underlying issues so that he can continue to run his own business and be a part of his children's lives.
All right, Mr. Benson, I have some questions for you. Can you step forward, please?
Your Honor, I apologize. When he steps forward, I think he gets cut off of the screen.
Oh, sure, no problem. If you can back a little bit, please. Can you raise your right hand for me, please?
Step back one more time. So one more step. There you go. Okay, perfect.
Solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. I'm reading throughout the PSI report that you don't accept responsibility. So let me ask you this. What was your responsibility in all of this?
I put my hands on Chantel Mayfield when I shouldn't have.
Wait a minute. I'm sorry. I can't hear what you're saying. What did you say?
So I need to look closer.
You continue to speak up.
Just speak up.
I put my hands on Chantel Mayfield when I shouldn't have.
What does that mean? You put your hands on somebody? I put my hands on somebody almost every day. I shake their hands. I give them a fist bump, but I'm not in felony court for charges. So what does that mean?
I violently put my hands on her that night.
I bodily put my hands on somebody every day. Either I give them a fist bump. Sometimes people want to hug, and mind you, I only do that when they've had their COVID shot and they have on their mask. So I'm putting that out there for everybody. So I'm still very careful. So I do that every day, but I'm not in felony court charged with assault, family violence, choking, strangulation. So let's stop using terms that you're trying to minimize what you have done. Because you're here for assault, choking, strangulation, and I know the complainant is taking responsibility, and I personally think that she needs to see a counselor to be taking responsibility for someone who put their hands on her. So you want to explain to me what responsibility are you taking in all of this? Because your attorney told me you did the BI.
After all the tough talk and a clear demonstration that the defendant lacks judgment, the judge makes a surprising call: 3 years of deferred adjudication, not prison. Why? This isn't a sign of weakness. It's a strategic sentence. The plea agreement had the state remaining silent, and the victim made a powerful, emotional plea for probation. By granting a deferred adjudication, the judge gives him the chance he asked for, but places him on an extremely tight leash. He now has a no-contact order, mandatory therapy for substance abuse and sex addiction, and random drug testing. This sentence comes with a built-in hammer. If he violates any of these conditions, the judge can revoke his probation and sentence him to prison time without the need for a new trial. He got his freedom, but it comes with zero room for error.
PP course, part of that is realizing what you did wrong. So what did you do wrong?
I did realize what I did wrong. I choked her.
Okay. And why is this happening?
And I choked her.
Okay. And then people, I see somewhere in the report where they're blaming this on an age difference. She's 46, you're in your 20s. Does age difference have anything to do with you choking somebody?
No.
In a powerful final statement, the judge hammers home the core truth of this case. Somebody waking you up is not a free range for you to hit them. It's all on you. Patrick Benson avoided prison, but he is now under the court's strict supervision, a direct result of a hearing filled with incredible twists, from the victim's shocking defense of her attacker to the bizarre introduction of sex addiction as a mitigating factor. The judge ultimately balanced the victim's wishes against public safety, crafting a sentence that offers a path to rehabilitation but promises swift consequences for failure. What do you think of the verdict? Was probation the right call, or did he deserve prison time? Comment with your thoughts below, and be sure to subscribe for more in-depth courtroom analysis.
No, ma'am, I never said that.
Well, I mean, I'm reading the report. It says you're minimizing your role in it, and it appears that the complainant is helping you minimize your role in all of this. So what have you done, and what have you learned so that this won't happen again in another relationship?
First, I have to fix myself. I have to address the issues I have within myself. I've had problems that I've been hiding my entire life.
And I know your attorney mentioned sex addiction, but there are plenty of people who may or may not have a sex addiction. They don't go around choking people.
It's true.
Yes, ma'am, I know.
That's not consensual. So if you're drug tested today, what are the results going to be?
It's going to be positive.
For what?
I drink alcohol and I smoke marijuana occasionally.
And what else?
That's it, ma'am.
All right, this is what the court is going to do. The court is going to deny your application Court will find you guilty, sentence you to 2 years in the state jail facility.
Meanwhile, in our universe,
Court is going to sentence you. I'll give you your deferred adjudication. The complainant wants you to have deferred adjudication. The state is silent. 3 years deferred adjudication, $1,000 fine. That'll be probated. There's to be no contact with Chantel Mayfield. There's an affirmative finding of family violence. Take into consideration 2020 CR 2861. You're going to be tested for levels. Those levels had better start going down. After he gives a negative UA, Rebecca, then it'll be random UAs. There will be regular reporting by Zoom or in person. Parenting classes. The BIPP course, if he's completed that, Rebecca, and provides proof of that, that will be acceptable to the court. Field visits. Random, 2 times per month. 100 hours of community service restitution. So the witness testified that you detail cars. Is this some sort of business or do you work for another company?
I started the business 2 years ago, ma'am.
All right, proof of employment. Within 30 days. No employment as a home health care provider with minors. And Rebecca, I guess if they have some sort of therapy for sex addiction, see if you can get him into some kind of therapy for sex addiction. And if he already has a therapist for that, then he's continue with therapy. Rebecca, is there anything else that he needs?
No, ma'am.
All right, Mr. Benson, is there anything else you need from the court in order to be successful?
Well, Your Honor, I do need to clarify on that a couple of things. I didn't hear you say intensive outpatient treatment. I may have missed it.
He's doing UAs. Mr. Benson, do you need treatment for drugs?
He has already registered for intensive outpatient treatment and is starting it. So,
all right, so I'll put down intensive outpatient treatment. Thank you, Ms. Sawyers.
Yes, Your Honor. And then also I have a question about communications. When you say no contact, can we have a carve out that allows for communications on an app? It's like Our Family Wizard. I can't remember what the free one is.
Close app.
Close app that allows them to communicate regarding a child, and also that will allow for supervised visits with the child, but not in the presence of the mother. Maybe it's like a family member or some other option like that. But the only communication they can have would be regarding the child and over, this app close.
No, he'll have to do that through a third party. I'll see how he does on probation and I may consider later. But for now, he needs to do that through a third party.
Okay, thank you, Your Honor.
Mr. Benson, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? Mr. Benson?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And also because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, I'm going to send you to breakout room number 1. Probation will go over conditions with you. And with that, we'll close the record. And Mr. Benson?
Yes, ma'am.
I heard the complainant try to take responsibility for you hitting her. It's all on you. Somebody waking you up is not a free range for you to hit them. You understand?
Yes.
Somebody questioning if you're cheating on them is not a free range for you to hit them. Do you understand?
Yes.
All right, I'm sending you to breakout room number 1.